Hey, everybody. So we've just come from the Celsius court hearing, which was an item that was adjourned from Tuesday's court hearing. We'll just wait for more people to arrive, and we'll invite some more people on stage. If you have any questions, so I created a thread on my Twitter with all the items that were to be covered today, and also a bunch of other documents that came out prior to the hearing. So you can catch up on the whole thing there, or you can just join in. If you have any questions or comments that you'd like to bring up based upon the court hearing, then put your hand up and we'll make sure that we get round to you. I'm going to try and keep this to about 1 hour, 2 hours max to get through as many questions until we either run out of time or we end up with no more questions. But we're just focused on the singular topic of what was covered today for Celsius creditors. And the main topic of the day, while more and more people join, was around the breakup fee and the expenses fee for NovaWulf and the structure of it. One of the things I do want to say just before we bring some more people up is this was probably one of the most efficient and productive court hearings that we've seen in the Celsius Chapter 11 case. It was a really interesting communal effort between the debtor, Celsius, the various ad hoc leaders. We mainly heard from, briefly, David Adler from the borrowers group, regulators, and the judge actually doing what I would consider a really, really good job of making sure that the appropriate questions were answered. But at the same time, a bunch of us creditors wanted to ask questions about the plan, and he did get quite aggressive. He got quite aggressive on a couple of occasions with Lawrence, who maybe he'll come up today. I know he had some issues on Tuesday's space because Lawrence wanted to say some things and the judge didn't want to take what Lawrence was saying. And also when Milbank, representing the Series B shareholders and their group, he got quite aggressive, saying that he was the Milbank, the legal counsel to the Series B, wasn't allowed to ask a second round of questions. So, but I also just want to say that there were some amazing questions from creditors. I had a bunch of questions, but the judge shortly told me that this wasn't the place to really discuss the plan. However, other creditors, and I think Manny did an excellent job of bringing up a point, and so did some of the other creditors that I list in the thread, that it's hard to, sign off or want to sign off on what might be a $13 million fee for expenses, up to $13 million of expenses, and a $5 million breakup fee, without really understanding whether the plan is something that creditors are going to vote upon or not. As well. Obviously, we understand many of the dynamics around the convenience class, the bribes, and how clawbacks and preferences are being used in order to bribe different classes into the plan. But at the same time, those that are going to have a meaningful vote in terms of, obtaining 50% of the value, and I think I always get this the wrong way around. Someone can correct me. It's either 2/3 of the value and 50% of the number of people that vote. They've got to achieve that, or it might be the other way around. Someone will correct me when they come up. So as long as those parameters still exist, but we know that they're setting up for plenty of cram down. So clawbacks are really being used as a mechanism to bribe this plan through, and a better recovery for the convenience class. We know all of those dynamics, but hopefully there's still a bit of a battle around that, and our vote actually matters. So lots of creditors asked some really good questions, And the judge kept bringing us back to framing it in the context of the singular issue that was part of this court hearing, and that is, whether the judge will approve the up to $30 million of expense claims and $5 million breakup fee. That led to lots of clarifications. The U.S. trustee, we've heard from the SEC for the first time, and it was the same SEC lawyer that was involved in the objections to the Voyager case. They didn't bring much to the table today. They said, but the judge was pressing them to really get their objections out early, and not kind of surprise us last minute. And I think creditors and the regulators and the US trustee and the judge all were trying to impress upon everybody that we want to hear the objections up front. We want to understand a bit more about the disclosure statement before we can actually make the decision about whether a potential liability of $5 million plus $13 million, so $18 million, is something that we want to sign up for. We also heard from the UCC. There was rumors out there online that Greg Pesh is no longer part of the case. Those rumors are false. Greg was on the call today, and for the record, there was a little bit of a tick for tack on the because as one of the arguments that was being used is that NovaWulf have expended significant on the plan. And to be honest, I know exactly how expensive this plan is because I was the originator of the plan, and I tried to put that in the record. And other creditors said that although they've expended a lot, it was a structure that came from us, because I think they were saying that NovaWulf came up with the plan and the structure. So just putting that out there for the record. Not that it's that important. Okay, so that was really the case. And we went through lots of different scenarios. And so one of the scenarios, and again, correct me if I'm wrong, because I was trying to write notes for creditors at the same time as listening in, which I'm a man, it's a bit hard to multitask like that, to listen and write at the same time and deal with Twitter at the same time as asking questions. But I did my best. And so some of the things I actually would probably need to return to my notes. But I think the most important thing here is that it is set up as a stalking horse bid, which is something that we fought for. And that means that if NovaWulf ends up winning and getting approval for the plan, then those fees are not chargeable. But there's a set of scenarios where they are chargeable. And those scenarios, the judge really wanted to drill down on. What happens if it moves to a Chapter 7 liquidation? What fees would they receive under that set of circumstances? What happens if it moves to an orderly Chapter 11 liquidation? What fees will be chargeable in that set of circumstances? What happens if everything moves forward, but they just can't get past the regulators? What happens to those fees in that set of circumstances? And what happens if they get approved? And if they get approved, those fees are not chargeable because they've got the plan. And the real thing, I think, the main point here was the chicken and egg of being asked to sign up to a big commitment of $18 million potential exposure to the estate, to Celsius creditors, when we're already paying for Centerview, we're already paying for Kirkland Ellis, we're already paying for all the other advisors to the UCC. And so other creditors brought up the fact that this is like a triple whammy to all of us. And I think the judge is very sympathetic to that. And he was actually really putting forward our case. They also confirmed that there is a credible group and syndicate of alternative bidders. I can confirm that because I know that to be the case. And they confirmed, the UCC confirmed that, that is a group of parties, and they want to get this first bid out there so that they can test, whether they're actually going to deliver the goods or they're just talkers. And so that's really, really, it's the way that we try to lobby for to get this stalking horse rather than a sponsor, so that alternative bids can come up and we can try and drive some of the competitive tension. And everybody seems to be on the same page around trying to make that happen. They did confirm that Centerview confirmed it was one of the most complex structures that they've come up with. I know that from our interactions with Centerview because it took us a long time to explain the various elements of the structure to them. And obviously, we created the 7-part video series, which was used as training in order to, as new members were brought onto this case. So hopefully, that has all played its role in getting to this stage. And I think the elephant in the room came up for really the first real time, which is regulatory structure. And we're really starting to see many of the things that I tried to prepare everyone for about 8 months ago when we first started. Seems like such a long time ago. I said that to get a plan through, it would have to come through an alternative bidder. It would have to be new management, new regulations, new licenses, new risk model, and all of those have come to be true. There was also one of the creditors that brought up the whole cell token issue, and that obviously was the big objection in the Voyager case, was the VGX token. There's going to be a bigger objection in this case, but it's all part of the negotiations that will come through. We're expecting to still receive a disclosure statement, which Centerview confirmed was one of the most comprehensive disclosure statements they've ever had to put through, was the way that he framed it. And there was just generally lots of discussion. So everything is kind of becoming a reality right now. It's a shame it took us this long and over $100 million of fees to get to this point. And obviously, we've got the whole Series B part becoming an important part of the equation. I tried to explain some of the dynamics in the last space I did on Tuesday around that. I think I failed pretty miserably because it's more of a visual thing. But there's, 3 different entities within this structure that, well, there's more of them that become important. There's Celsius, the network LLC. There's Celsius Limited, which is the UK entity, and then there's the Celsius Inc. And I went through some of the shareholding structure. Basically, the parent company is 64% owned by Celsius Inc. And Celsius Inc. is 86% owned by Alex Mizhinsky, and the rest owned by Daniel Leon. And obviously, Celsius Limited. Alex Mizhinsky is still the director, but we've got the special committee that the UCC have told us are the decision makers in that process. So there's this intercompany loan where essentially, the record keeping was so bad that $9 billion of transactions were not recorded correctly. So in the examiner report and other types of reports that have come out in this chapter 11, that got put down. Coinbase stated that 7,000 records are missing and it would be impossible to do it. So they determined that $9 billion intercompany loan is worth approximately $3.5 billion. And that really determines the point at which the shareholders are going to be in the money or out of the money. And so the speed of the transaction becomes quite important because they anticipate the net asset value of this is going to be approximately into the NewCo. So 100% of the shares go to creditors under the proposed plan. And they estimate the net asset value will be approximately 1.9 billion. So that would fall underneath that. But the price of Bitcoin and crypto becomes an important parameter here. Because if that went deeply in the money, there's a risk that we could be made completely whole in US dollar value, which is what happened in the Mt. Gox case, by the way. So people lost their Bitcoin. They only received approximately 10% of their Bitcoin, but in dollar value, they made their money many times over. And so the higher the price goes, the less crypto you can end up receiving in that scenario. So I believe that part of the Series B long shot, which is also aligned to Alex Mashinsky's interests, because most of his claims would be subordinated or clawed back, is on along the lines of what happens to those shares if it becomes in the money, and by in the money greater than $3.5 billion. It's a bit complicated, and sorry if that's a complicated explanation, and I may be wrong on some of these matters, but it's just the research that I put together. So don't take this as legal advice, financial advice. It may have tax implications, it may have return implications, and it may have legal implications. So just providing that for information purposes only. And with that, I think it's probably a good time. I'll invite some of the various people. So we'll invite Tony V up on Tuesday. They got a settlement for the custody case, which I believe was approved. So I've invited Tony V up as a speaker. The ad hoc group of borrowers have been very quiet because they've been really busy negotiating. So I invited David Adler and Ronan. Haven't seen either of them yet. They may be really busy just working on negotiations, and they don't want to publicly speak on anything until that has progressed. But David Adler today did confirm that they believe that it is in the interest of creditors, because they have reached what they believe to be an initial agreement with a bit of tweaking, that we just get that first offer out there so that we can then test the competing bids with the stalking horse setup as well. So Ronan's not here at the moment, and David Adler isn't here. If they join, we'll try and bring them. We'll bring them up. Yeah, that's about everything. Sorry, Tony, I know it wasn't really covered on the hearing, but is custody now, is that a done deal? Has the judge approved that? Is that?
Yeah, the settlement is pretty much finished. The only thing left to do is, I guess, either accept or decline the settlement. I don't know when Kirkland's going to send that out, hopefully soon. And then people will have 30 days to vote yes or no. And then probably shortly after that, we should be getting the first distributions.
Okay, great. And I was glad also today to hear a talk about. I mean, to me, this was an exciting hearing because this was kind of my topic when we start getting into structuring around securities. And as somebody that's been involved in structuring securities in this space for a long time, very familiar with the regulatory hurdles, and a bunch of the regulatory hurdles were brought up. One of them that I know to be true is the specific ATS approval, which is the mechanism for a security token trading as a security token on a non-national exchange. So a national exchange would be somewhere like INX actually acquired one. I believe T0 has as well. But then you can have a broker-dealer, which is approved by the SEC as what's known as an ATS, which is an alternative trading system. That's where you get specific approvals from the SEC. There are possibilities that ATS doesn't approve you to trade tokenized assets. And from what I can see, that would be an approval that would need to be achieved with the SEC in a regulatory hostile environment we find ourselves in today. But Judge Glenn really wanted to get ahead of that and say, look, you've got till Tuesday to really let us know if you've got objections to the fee proposal, because if creditors are going to enter into this very expensive agreement that could dilute the value of the estate, then we want to see and hear from you either way by Tuesday on this particular matter. But the SEC kind of non-committal said in true SEC format that we're experiencing right now. And Judge Glenn brought up the whole Coinbase case, which I tweeted about earlier. For those of you that don't know, Coinbase in 2018 acquired our US broker-dealer in ATS because we were working on tokenized securities. And then we sold it to Coinbase so that they could have the SEC coverage that they needed in order to sell tokenized securities. And in that whole time, it hasn't actually been approved for that matter. So Judge Glenn really brought up what's happening with Coinbase at the moment. So the SEC is still the big elephant in the room. And one of the big things is obviously mining as well. So, with Bitcoin heading new price levels, we received some figures and financials from Celsius for February. And it looked like some of the things that Keith were pointing out in terms of how they're using depreciation and amortization is really where the confusion is lying between whether it's profitable or not profitable. But we started to see better numbers that allow us to really analyze the feasibility of the mining operation. And obviously, we're the debtors, so it was a big intercompany loan that is creating some of the debt in that structure. And if we approve the plan, we'd be wiping out that debt, which would be us. And then that could be a debt-free mining operation where we can put it to proof of work, which I'm still very keen to see if we can do that, so that at least we can put this whole Celsius scam to use, powering the most important network in times of central bank digital currencies. But I deviate. Let's stay on topic. Okay, all right. So let's. If anyone's got any questions, then let's bring some up, Azad.
Yeah, let's bring up Craig.
Yeah, thanks, Simon, for doing this. Hey, I had a question. Celsius said the 1099 miscellaneouses that they sent out to U.S. customers were no longer valid. They were going to reissue the 1099s. But if you log into the app and under tax forms, it doesn't have any new 1099 issued, and the April 15th deadline is coming up. Do you know anything about that?
I don't know about specifics. I just know that the UCC and Celsius tweeted out that they're going to be resolving that. I can imagine it's a hugely complicated thing for them to do for so many users. So it's never going to be straightforward. But I think the amendment, and don't quote me on this, is related to, after the pause. So the tax is probably due pre-pause, even though the coins belong to Celsius and all the complications around that. But I think they're making an amendment based upon post-pause yield, because Celsius, for whatever reason, after the pause, continued to pay fake yield, which wasn't, because we know it was just database entries as opposed to anything else. So I think that they're adjusting the tax based upon the post-pause yield that shouldn't be taxable. So correct me if I'm wrong, if anyone knows otherwise, not tax advice, but don't expect a big difference. But they are reworking some of those things.
Yeah, and hopefully they'll have that out before April 15th. If anyone knows the answer of when that's going to be completed, that would be awesome. Thanks again, Simon.
Yeah, cheers, Craig.
Okay, let's bring up Lawrence.
Hey, Lawrence, we tried to get you up on Tuesday. Your infamous "this is bullshit" court hearing last Tuesday, which I don't think the judge heard, but it sounded like the judge is not your best friend. So you continue to push back. What were you upset with today?
I think Lawrence is still trying to connect. So whilst we wait for Lawrence, let's bring up Elias.
Let's get some serious censorship from Elon here.
Elias, can you hear us?
Hey, Elias, you around? Oh, no, we're not going to repeat Tuesday, are we? Where everyone comes up and they can't talk.
Elias, you're going to have to unmute yourself if you can hear us. We're trying to connect with Phil as well.
Again, if you've got a question, put your hand up now. We'll try and bring a few people up on stage, because for some reason we keep getting these issues of people coming up and not being able to speak. But we'll keep this going for either on the hour or a couple of hours max. Or if there's no questions, we're just going to end early. I'm sure there's plenty of questions, so speak now or forever hold your peace.
Okay, Lawrence is trying to connect again. Let's see.
گرفتم کونتان و اکانومی عجیب.
Is that Elias?
Hello, how are you, bro? How are you?
Hey, Elias.
Hi.
You got a
How
question?
are you?
Oh, very well, thank you. How can we help?
Thank you, bro. Thank you.
Yeah, he's a troll. You can kick him out.
Okay. First person up is a troll.
Simon.
We got Edo M or Edo M. Can you hear us? Man,
I can hear
Elon.
you. What's going on, guys?
Hey, Elon.
No, it's not Elon. Sorry, I'm just complaining to Elon live.
Oh, right, okay.
If he's listening. Edo M. You got a question for Simon?
Yeah, Simon, I sent you a DM and you never got back to me. I got an idea, 5 minutes, and it can make millions of dollars. Hit me back.
Is it okay? All right. I don't check my DMs, and not the kind of pitch I'd respond to of it can make us $1 million in 5 minutes. Sorry to say that. That's not going to get my attention, probably.
Okay, right. It's a comedy hour, maybe.
No, I do get an incredible number of pitches, obviously, over the years. So that's just a bit of a tip. Yeah, making $1 million in 5 minutes is probably not going to work.
No. All right, let's bring in M&M.
Yeah, hi guys. You there?
Hello.
Yeah, mate. Yeah, Simon, I just want to get your thoughts. Today we got, I guess, a little more clarity around what the plan will be, where they stated ETH and staked ETH won't be returned, and also it sounds like there will be no benchmark for the management fees. Just wanted your thoughts on that.
Yeah, so they want to charge. So they said the figures that we got, and they were non-committal because they really want to put it in a disclosure statement. Because making forward-looking statements, obviously, we'd all love to hear those and get the numbers, but it has to be surrounded by a bunch of disclaimers, a bunch of information, and until they do that, they'd get themselves in regulatory trouble if they commit to things. So. But we did hear that they estimate that the net asset value would be $1.9 billion is what they think. And that does include all of the staked ETH. Obviously, that's a big part of the negotiation with the borrowers because they want to use that as the collateral and the income as the business model. So to me, that's a huge downside part of the plan relative to the one that we originally structured and proposed. However, I understand why they did it that way because they're looking to renegotiate with the borrowers and get a one-way bet on the collateral side. So we'll see what the negotiation is with the borrowers. They also confirmed that it would be part of the estate, and they've got this management share token, which is where they would receive an upside based upon the equity value. So it starts with net asset value, which is the value of all the assets, which would go through a disclosure statement and a professional audit stroke valuation of those assets. But ETH is the only liquid asset, from my understanding, that they would put into Nuco. And then they would be charging based upon the upside value, but we would also get a cut of that in the future as well. I don't really like that model. I'd much rather have, a traditional 2 and 20 or something like that, where you have an admin fee to cover costs, and then they have to make profits, but you have a benchmark. And given that a significant amount of the assets would have been ETH, I would put ETH as the benchmark rather than dollars as a benchmark. So I expect when we get the full disclosure statement, this is probably going to be one of the more contentious issues. I brought it up, and other creditors, Manny brought it up as well. And so I think this is going to be a contentious pass, but we got the confirmation that they will receive a fee based upon the value of ETH going up, and we will be forced as part of this plan to transfer at least all of the staked ETH. And I remember in the term sheet, they said this concept of qualifying assets, which they would charge fees on. And this is what they would consider an illiquid qualifying asset. So that was a confirmation we got. This is what I think will be one of the more unpopular parts of the plan. So we shall see. I remember Judge Glenn, the Centerview was saying we've got a couple of weeks to release a plan, and Judge Glenn was like, you got till the 31st. That's like a week away. So we expect to see a disclosure statement pretty soon to meet that deadline, because exclusivity ends at the end of this month, obviously. So we get to see exactly what they've got.
Yeah, I guess the benchmark's probably one of the main things I'm looking for in the disclosure statement, for exactly that reason. You know, if it ends up in liquidation, I don't need to pay anyone a fee just to hold my crypto long term. You know.
Yeah, and his argument was the management share token does alleviate some of that issue.
Yeah.
But to be seen.
Yeah, no, I'll definitely be looking forward to it. Just a quick follow-up question, I guess, on the valuation going forward. So they said that, you know, the management fees will transition to a percentage of the net asset value after, I think it was a couple of years. How does that get revalued each year? So, for example, if we have a huge run in 1 year and then it drops, I'm assuming they're not going to take a loss on the following year. Does that get revalued so that they only take the upside going forward? Is that how it typically works?
So this isn't based upon profit. This is based upon actually receiving a percentage of the value of the equity share token, the EST. So they're actually going to take a clip on the value of the EST eventually, but initially net asset value. So they use the figures of anticipating that after year one, they'll get 35 million, which would obviously make back the 45 million that they contributed, which also they probably earned by buying discounted claims, because they'll obviously, they get a bunch of claims and there'll be a margin based upon the purchase price of the claim versus the crypto they receive back. So you can see how they've structured it in order to fund that.
And the net asset value, am I also correct in assuming that that will not necessarily be the value that the tokens will trade at on, I guess, a public market?
No, yeah. So initially it would just be illiquid net asset value. There'll be a price for ETH at the end of the year, is my understanding. And then the mining will have a valuation attached to it, and the loan book will have a valuation attached to it. And then eventually they're trying to incentivize us to this becoming, you know, the EST actually trading at real market value. One of the creditors brought up, I think it was, sorry if I'm not giving credit to who it was, but someone brought up that they typically trade at a 50% discount using the GBTC example. And then Centerview commented on that as well. But yeah, my understanding is initially net asset value, then after 5 years, it should be the value of the EST, and the MST is meant to tie us together to the success of whatever fee they end up charging at the end of that period.
All right, I understand. Okay, thank you.
One of the things I'll make sure that I'm doing is I think I should be getting, I was meant to have one this week, but I was traveling. But next week, hopefully, I'll get my first meeting with NovaWulf to really try and ask some of these questions. I created a Slido board. Sorry, I've lost it in all my tweets with all this banking stuff happening. I'll try and pin it to the top as well, where you can upvote questions. So we had like 200 different questions on the plan. Azad, if you get a chance, maybe you could tweet that out and pin it to the top, or I'll do it at some stage. But yeah, that is, you know, you can ask your questions there, and I'll try and ask those to the NovaWulf team when I get to meet them with the UCC and Celsius.
All right, let's bring up Eric.
Yeah, hey Simon, Azad, my man Tony, how's it going? First of all, if anyone has any $1 million ideas that I can make in 5 minutes, feel free to DM me. Unlike Simon, I'll do that. No, just kidding. Yes, Simon,
Yeah,
I was.
I've got it. Send me $1 million worth of
Right,
Bitcoin, and I'll send you back 2 million.
right. Um, yeah, I was the creditor that brought up after you went on record about the plan. I was the one who brought it up to the judge or to the banking company, and the reason that I did that, or I guess what are they called? What is it? Boilerplate? What's the name of the company? No,
NovaWulf,
I wasn't trying to be funny. What? Oh, no, not NovaWulf.
boiler room.
No, right. Yeah. No, the
Which
dude
one?
who was,
The investment bank,
yes, yeah,
Centerview.
Centerview. Okay, yeah, he seemed very articulate and definitely knowledgeable. What I was basically trying to bring up was you laid the foundation essentially for this plan, and you did it essentially for some Twitter followers and a Shake Shack burger, and they have the potential to get upwards of $18 million when it's all said and done for a plan that you created. And I believe that potentially a little compensation is owed to them for coming up with this staking horse bid, which you also had to advocate for. We had to advocate for, otherwise that might not have even happened. There has to be some sort of rational deduction of like where's the math on this? Like what I asked the judge, like, or I asked center, whatever they're called. I asked them how much was NovaWulf making on a monthly basis, and they couldn't give that out. Because to me, I feel like $18 million for 3-4 months of work, or even potentially 6 months of work, could pretty good. Like who kind of wouldn't take that deal on this call? And I think that I don't know. I'm assuming it's precedent that companies who win a bid or a stalking horse get some sort of breakup fee in America. But if they weren't really entertaining your plan because of where you're domiciled, where your jurisdiction is for your company, then they have to live up to American standards. And American standards are we are a democracy. At least we believe that we are. And it's the cost of doing business. Otherwise, I believe that other potential bidders, either in this process or, well, actually, it's too late for this process, but in future bankruptcy processes, companies are just going to start putting bids. I mean, I can write a nice proposal, even if I can't fulfill it. Right? I could just start writing proposals for the chance that maybe my bid or someone else's bid gets selected by future UCCs, and now I can make some money just doing that, even if I have no real intention of fulfilling the plan or whatever. And I just feel like it's going to open up the bankruptcy process in America to a complete shit show in the future. Although I really particularly care about this case. I don't know.
Yeah, I think it's a really good point, Eric, that you brought up, and it's kind of also the precedent of launching an illegal bank, not applying for the licenses, getting yourself up to $20 billion in assets, then going in Chapter 11 protection, and setting a precedent there that there is now a mechanism based upon launching an illegal bank without the license and then trying to get approval in Chapter 11 for a reorg plan is probably a better strategy than what Coinbase followed, which is try and apply all the laws, try and acquire the companies like the broker they bought off Bank to the Future, tell all the regulators what you're doing, not get a reply, and then suddenly get a really expensive case with a shakedown from the SEC. So there's really interesting. I think you brought up a really interesting philosophical point of the failures of this system. But at the same time, I think we're just trying. But I think you used it as a negotiation to try and get the fees down. We got from 15 million to 13 million. Now, if I was playing devil's advocate, we tapped out at 1.2 million, and I knew that this was going to cost us. But we were estimating 10 million to find out whether we win, and approximately 20 million if we were going to win. And we tapped out at 1.2 million when we realized that due to US politics, we were not going to be a part of this process. We weren't in the old boys network, and there was a bit of banter between Greg Pesh, UCC, and myself and other creditors in this case, because quite frankly, yes, we did create the structure. We spent a lot of money on the whole structuring side, and then yes, it was it was given to those that meet the political. But I do want to be fair in this process. I do think that NovaWulf, because they are a registered investment advisor and Figment has the ATS. While we had our partners in our bid, the court is definitely, and the regulators are definitely going to want to work with a US first, US located, US political, US taxpayer, and all that stuff. So I think they're going to have a better shot at this. But at the same time, we do know that competing bid is coming through, and they are all US first, US centric companies that are looking to put together a syndicate as well.
Yeah,
but I think, you set the point.
Yeah, I was gonna say you kind of also touched on where my underlying frustration comes from, and I don't want NovaWulf to disappear, and I want to progress this for all creditors, in my opinion. But what I feel, and I believe many creditors feel, is that there's definitely some sort of sweet relationship between NovaWulf and the lawyers, right? The boys club, as you called it, and that's where my frustration is because these lawyers could say to NovaWulf, hey, come out, do this, make a little money. If you don't get picked and some other bid comes out, then you walk away with some money. And if you get the bid, congratulations, you guys are making money off of the backs of creditors. So that's really where my underlying frustration comes from, is that, dare I say, had this been you in this position, and your plan was the one that's the staking horse, I would believe that you would be entitled to compensation. I also don't believe that you have any, secret relationships with the lawyers, unlike NovaWulf, and that's really where my frustration came from this. But I don't want them to disappear. And thanks for your time again on the space.
Yeah, thanks, Eric. I did try and turn this into a Bitcoin company rather than a TradFi, and the UCC did say it's their experience in traditional finance, having managed, I think they said hundreds of billions. I'm not sure if that's accurate. But was the reason why they did that. So they've definitely worked on many bankruptcy deals in the US. They are distressed structurers, and I think it was their experience that the UCC was trying to say. Whereas we're a bit of a Bitcoin OG company, we would have turned this into a Bitcoin company that got lots of pushback in the early days of this case. And we highlighted all of the issues that turned out to be the issues. It just took 8 months for everyone to come on the same page and realize it once it hit that stage in court. But yeah, I do feel certainly shafted. I think I've the largest creditor, the one that had to cover the seventh largest creditor, the one that had to cover all of their own expenses in trying to come up with this plan, and also the one that got shafted by Alex Mijinski and Celsius the hardest, with a no loan, no collateral treatment, where I was the only one on the platform that was treated that way.
And by the way, that was the other thing I was going to say, is that at least you have skin in the game, and NovaWulf doesn't have skin in the game. And speaking for myself, whether it would be you or another one of the great creditors that we have, unfortunately, as part of this process, I would vote for them over an outsider just because they've lost. We lost, right? Skin in the game, and that there's value for me in that, in where my opinions lie. But again, thanks for your time. Oh, the other thing I was going to say, sorry, I was actually impressed by the judge speaking about Voyager. The judge is not stupid. He's paying attention to everything moving. My jaw hit the floor when the SEC, spoke up and showed her face. But this judge is a very savvy judge, in my opinion, from what I can tell. We obviously not all of us are going to agree with every decision the judge makes. That's unfortunately the way the American judicial system works. But he's hip to the game, I think. And that's all. And I was actually impressed by that. So that's all I would say.
Yeah, I agree. As a non-crypto judge, and I don't think there is a crypto judge, he really is. I felt today he represented our interest better than I've ever seen. So I think he asked all the really important points. He pushed hard. He's trying to get this done as fast as possible. And today was probably, of all the court hearings, this was probably my most favorite, where I think we made the most amount of progress, and it seemed like all the parts are coming together.
And he didn't make a decision, right? So he's open-minded about really weighing where he rules on this matter, I guess.
Well, one of the best parts I think about today is it was a team effort with all the creditors coming up and asking the right questions, not the stupid questions. And you know, everyone really working on a team effort to look out for creditors as much as possible. And I felt like the judge was really on team to try and look out for us in this process.
Cool, thanks. You can send me down, as I appreciate it.
Yeah, and our buddy Hairline Keith Wolford represents TerraWulf or Beowulf, one of the wolves. So just keep that in mind.
Yeah, and obviously a big advantage of the wolf relationship is that they're kind of just saying we won't push back on the litigation trust plan, and we've already seen in the Binance Voyager side that Binance can acquire those clawback exposure and they can reduce it. But in this one, that doesn't seem to be happening. And I know why. We all know why. It's because it's part of the bribe to get the plan through so that everybody agrees to eliminate their clawback exposure. And then the litigation trust can be, run as a Chapter 11 2.0, as it were. And we need to make sure that the terms of the litigation trust become really important as well.
Okay, before we bring on the next speaker, which is Gene Martinez. Simon, since you're the host of this Twitter space, it's been suggested by Natty that Lawrence and Natty are probably blocked. That's why they can't come on as speakers, but I'm not too sure if that's the case.
Blocked? I definitely wouldn't be blocking Lawrence and Natty.
Yeah, no,
I don't know if you are, Azad. I don't think you would.
No. I haven't got that control, but
yeah.
Yeah.
Let's have a look. So, no, I'm definitely not blocking Natty. I just invited you to speak, Natty. And yeah, you're definitely getting censored in this Chapter 11 process for some reason.
Yeah, if we can keep trying to get Lawrence up. Lawrence is having issues as well, just coming up. Okay, let's next speaker, Gene Martinez.
Thanks. And Simon, first of all, thank you for taking the time.
Can you hear us,
for doing
Gene?
this.
I can actually hear him, Azad, but I don't think you can.
Oh.
Okay. Yeah, I was just thanking Simon. And Simon, if you ever feel like, you're getting attacked or, that you're very stressed out, just know that all these spaces, it's helping so many people. So again, appreciate it. My question is around the treatment of earn versus custody. And I apologize if this has been answered before, but in a jurisdiction where where Celsius wasn't actually allowed to do earn, like New York, let's say, but you are in earn, is there any recourse to say, well, I'm actually not in earn, I'm supposed to be in custody, that was a mistake? And the second question would be, where would you rather be, custody or earn, if you could even swap that or switch it? Hopefully that makes sense.
Good question. Well, what is interesting, and Tone can correct me if I'm wrong about any of this stuff, but custody are actually getting 0.7, 0.772. What is it, Tone? 77.5? Are you getting
72.5% in kind?
72.5, but paid in crypto, right? So if you had one Bitcoin, you're getting 7.72 Bitcoin. Is that correct?
Yes.
Yeah. To me, that sounds damn good in this process. A 27.5% withdrawal fee versus. But I will reserve judgment until we actually receive the disclosure statement, because for me this was risk capital. So to me that I was experimenting with taking out a loan against my Bitcoin, so I don't have to sell my Bitcoin, and it was Bitcoin that I was willing to lose in terms of where it fits in my portfolio side. But most people are totally not in that type of scenario. So the way that this is being structured is, I think it should be structured as an income play. I think we should really push the mining operation to pay out quarterly dividends until the machines are worthless. I don't think we should play a leverage play to try and build a growth company. The loan renegotiations might be a decent revenue stream, Hopefully, we could get it where they are paid out in Bitcoin. If the benchmark on ETH is ETH itself, then that makes it slightly more attractive in terms of the fees as well. But I mean, if I want to stake, I'll just stake. I don't see why I need a fund to do that, but I understand the structure that they put together with that as well. So I don't know which one. I mean, personally, yeah, based upon what I hear right now, I'd rather be in custody. But I reserve judgment until we see the actual plan, the disclosure statement, and that's going to be a beefy ass document to go through, probably as long as the examiner report itself. So we'll obviously be going through that. It's meant to come, and then everyone just has to really take their own, make their own decisions about whether they vote for that as well, because we'll see how it's all structured, but we'll obviously do updates there. In terms of recourse, if you thought you were meant to be in custody, now this is a very lawyer question. I'd love David Adler to answer it if he does come up, but I'll have a go. If you don't vote for the plan, then you won't settle, and if you don't settle, then you reserve the rights if you filled out a claim form against all the different entities. And if you didn't fill out the claim form, then I'm not sure you have the right against all the different entities. You just have the right against one of the entities, and that entity would be wiped out in this process. So the whole idea of voting for a plan is that you settle, you agree, and therefore you remove all of your rights to litigate, but you transfer some of that litigation over to the litigation trust. It is kind of the idea, and that's what the whole Chapter 11 process is. And then you understand what you can litigate for. But if you don't vote for it, then you reserve the right, and you would need counsel to progress that. So you'd have to make a decision about whether it makes it makes sense for you on a cost benefit analysis, and then you can object to the plan, and maybe you push it towards some of the strategies that other creditors are going for. So one of the other creditors is going for a Ponzi scheme determination, and that would be an unwind process in everything, which that creditor believes. I think that really favors the stablecoin holders more, but you've got all the borrowers, what happens to the borrowers, and everything that can come. And then I think everyone would just be equal. There'd be no difference between custody and earn, and then everyone would start suing. And we could be in a very lengthy process if we go through that. But who am I? I'm not a lawyer. I don't know. That's what I'm seeing.
Thanks.
Okay, sorry, I just hit the mute all button accidentally.
Thanks, Simon.
All right. Appreciate it. Lawrence, you've requested to come up as a speaker, so you should see a notification that comes up to let you know that you can come up as a speaker. You have to hit that. I think the same applies to yourself as well, Phil. Right, next speaker, let's bring up Al Micmac.
Yeah, hi, Simon and Nazar. Thanks for the space. Can you guys hear me okay?
Yeah, got you, Al.
Good stuff. Yes, slight shifting gears on my question. So even though Greg Pesh, I think in the hearing, said that the licensed custodian had yet to be revealed, I saw in the response to the objections to the bid protections motion that it was actually named by Celsius last night. So I was going to ask, Simon, if you've had any dealings with Anchorage Digital, or if you're aware of them or know much about them.
Yeah, I do. So Anchorage were in the exact right time and the exact right place to be the only federally authorized bank charter that was issued to a company in the crypto space. Other types of companies, they have partnerships or they have state charters as banks. But Anchorage, from my memory, was the only one that managed to get that at the right time, right place, right moment. And then since then, they haven't been issuing any other federal bank charters. If you've been following the Caitlin Long and Custodia case and the Operation Choke Point, you'll know some of the politics there that's been happening. But they are as good as they're as world-class a custodian to work with as any, in terms of, regulatory risk and regulatory exposure. So if they are the custodian, that's the perfect partner to work with in this case.
Okay, thanks, Simon. That's great to hear. So it looks like they're prioritising regulatory compliance above and beyond pretty much everything else, which is probably the right approach at this stage, isn't it?
Yeah, I mean, absolutely. This is the only way we're going to get through. It's a very exotic structure. In a sense, I wanted to ask, when we get the chance to ask, why bother with the security token? Because it seems like it's just a way of putting it in Figment, because we could just issue equity and it would be way less contentious than doing the whole security token trading thing. And I don't think trading is going to produce the liquidity and, the is the reason for doing it. So yeah, I think a competing bid could just issue just straight up equity with dividends, with no liquidity, and try and get as much liquidity up front through custody, which was the process that was the proposal we put forward. The security token's going to cause contentious. Sorry, Ali.
So do you reckon that might just be just to get out of Chapter 11, though, with potential to revert to kind of a more...
No, I think it's the opposite. I think if you took out the provenance blockchain and the whole trading on an ATS, I think you'd be way more likely to get out of Chapter 11. But if you want to achieve that, they're pitching it as liquidity, but it's the opposite, actually. It's the one thing that's, if the ATS, I think they may be using it to get the approval they want for Figment's ATS, because it's not actually, from what I can tell, approved for security tokens. It's approved for a secondary market. And from what I can tell, they haven't, and I could be wrong. I'll ask these questions. But it could be a strategy for just trying to get the approvals they need at Figment.
Yeah, or could it be that it's problematic to distribute equity? Say it was on the Nasdaq or something like that. It might be more problematic to distribute it globally rather than using the security token. I don't know.
No, it should be identical. So there's an exemption in the bankruptcy code that allows you. So when we lobbied for the whole Jobs Act, that took us about 5 years to lobby for in the US. It increased the number of shareholders that you could issue private equity to before actually becoming a public reporting company. So they increased it to 2,000. So once you take out the convenience class, from the calculations that I've done, I think if you wiped out everyone below 20K, I think when we did the calculations, that leaves about 78,000 creditors or something. Maybe someone else has done more up-to-date maths. It's just from memory. But once you go over 2,000 shareholders, you have to be a public reporting company. And if you're a public reporting company, whether you trade on an ATS or you trade on a national exchange like NASDAQ, the requirement would be pretty similar, I think. You'd have to file, I think maybe the difference would be the approval and S1. I can't remember what counsel advised me at the time. We did get advice around this. And then you've got a time period at which to backdate the reporting based upon how Celsius did the reporting. So Celsius is previous issues in reporting, because you have to create comparables to the previous entity. I remember our counsel just going through this big ass list of issues that I'm sure the NovaWulf team are trying to get through in order to release this disclosure statement and get it approved. But no, from my understanding, getting on NASDAQ would maybe potentially be, well, I guess if you're on NASDAQ, you'd probably do a reverse merger or something like that. SPACs are out of favor at the moment. That would be very, very hard to get through this process. Reverse merger would be difficult, but to get a new listing would certainly involve, because then you're dealing with the actual exchange approval process as well as the S1. Whereas dealing with an SEC registered ATS would be slightly more light touch. And then it also depends if they're going to have retail buyers or qualifying accredited buyers or just qualifying buyers.
Okay, thanks, Simon. Those are all my questions. Thank you.
Thank you, Al. Let's bring up Alt Monarch. Can you hear us? Okay, if not Alt Monarch, let's try Sean Connaughty.
Hey guys, how are things?
Hey Sean.
I actually spoke to you guys a few times on, well, you, Simon, a few times on Twitter. You responded to a few of my tweets. Thank you for that. I'm not a finance guy, so like, I try and follow along as best I can, and like listening to these conversations and even reading a lot of the tweets. Some of it goes over my head. So
you're not alone. You're not alone.
Yeah, a lot of my questions right now might seem somewhat simple to you guys. But just I'm an earn customer. I'm not in the US either. I live in Dubai. So in terms of like in terms of like a position from outside of the US, all of this talk now, is this specifically for customers that are US based?
No. So this is global. So it doesn't really matter what your jurisdiction is. I mean, it may determine your tax situation. Well, it certainly will determine your tax situation. And so living in Dubai would probably be a lot more favorable than those living in the US in terms of the tax treatment of this plan. But they're complying with US regulations, and it will be trading on an SEC registered platform. And so in securities laws, it doesn't really matter where you're from or where the company's from. As long as you have at least one investor from the US, it brings it into the jurisdiction of the US. And then globally, you then have local securities laws. And most people, one of the things we had to do at Bank to the Future was build an onboarding platform that took into account, if you're in Dubai, what the regulations in Dubai are. And we spent over a decade building that, because it's not just the US that's looking at these things. So but yeah, in general, how you are treated will be the same. It's they're starting with a US first plan, and assuming that it scales out from there.
Okay. And then relative to the claims process, when I received the emails in relation to the claims and how to do it from Stretto, is that the name of the company? Yeah, Stretto.
Yeah, Stretto is the one administering everything for us and administering the vote and claims and court dockets and everything.
Yeah, so basically they said if your name is listed, then you don't have to file a claim. Now, obviously, the claim, the amount that was listed for me was the amount that Bitcoin was worth at the time. Celsius shut down or stopped operating, which was less than the value of the Bitcoin at the time I owned, or I had put onto the platform. So would you recommend that I actually file a separate claim?
Well, I can't make any recommendations, but the deadline to file a claim has passed.
Okay.
So you can't file a claim anymore. But the important part is the date when they filed the petition, the bankruptcy date. So the only thing that matters of the value of Bitcoin when you purchased it is based upon your specific tax treatment when you're trying to determine if your Bitcoin was converted into a security token. That would determine some of your tax treatment. And if you live in Dubai, I'm assuming that your capital gains free and there's crypto exemptions, so I don't think it would apply to you too much. So I don't think you've missed out anything. The contentious part as a non-lawyer is that if it turns out that we only have a claim against one of the entities in the group of entities, and that whole scenario worked completely against creditors, then you may want to have recourse against different entities. And David Adler was trying to warn us about that process. And it's so complicated and filled with so much nuance that it's not just beyond you, it's beyond most people's comprehension. You've got to think about 15 chess games ahead. And I'm hoping that it's not going to come to that. But there's a possibility that you could be penalized for not filing a claim form, but we won't know yet. And I think it's a remote chance. I'm hoping that everyone's going to be treated equally at the end of this, but we just don't know yet.
Okay, and just sorry, one last thing. Obviously, I've looked into the possibilities of selling the claim now for a reduced cost. I heard you speak about NovaWulf buying discounted claims. There's also other companies like X Claims and I think Cherokee, is that the name of them? Buying up.
Yeah, Cherokee and X Claims. So they make a market in the claims, and one of their investors, it was disclosed, that was buying claims previously, I don't know if they still are, was one of the NovaWulf group of companies.
Yeah, well, they are definitely, because I keep on getting emails off them now offering me a percentage for what I own.
Yeah, it could be any investor though. You don't know if it's NovaWulf. I don't know if they disclose that to you until you actually agreed to sell it. Maybe.
Okay, and just I know, I don't know, like, legally, obviously, you're not allowed to give out advice here, or etc. But just like, do you think this is like, they're giving out? I think it's like a 18% or 0.18% on what I own. Like, is that bad? Like, in terms of how this could like work out overall in the long term, is that like?
Yeah, it's designed for for those that have to get liquidity because they need the money, or they need it. If you don't need it, then the theory is that a patient investor should do better than somebody that doesn't have the patience.
Okay.
Because there's a price for liquidity. So they're offering you 18 cents because that sophisticated investor believes that they will make a lot more.
Okay.
And, in general, I would say the consensus is that if we went into liquidation, we'd probably end up with probably 40 cents.
Okay.
So you're comparing it to, do I want the money now versus waiting years for a liquidation? And then the idea of the plan is that if it goes incredibly well, then they're aiming, the NovaWulf team are aiming to give us a full recovery plus a return. Which is what we did with the Bitfinex deal. We ended up at its peak, 16x on $16 on the dollar, plus hundreds of millions in dividends, and the recovery from the hack tokens, which once the DOJ hands them over, there's a bit of a recovery on that. So that was the goal. Whether that happens or not is complete speculation, and that's what the disclosure statement is designed to do. It's designed to show you that they believe this plan gets you a better plan than the recovery. And so if you're willing to take the risk and you have the patience, then it's meant to get you a better recovery from that, with a bunch of disclaimers that everything could go wrong.
Okay. And just one final thing, it's a short one. In terms of like being a patient investor, can you put it like a timeline on how long this might take?
For returns, or for the plan to get implemented in our first distribution?
Yeah, well, the latter there, please.
Yeah, I imagine, I don't know if anyone else has got an opinion. They put the deadline of trying to get the first distribution by, I think, July. I don't think they'll meet that. I think it will be by the end of this year. So I would be very disappointed if we didn't get a distribution this year. But I don't think you can plan much further ahead, because everything else would be a bonus.
Okay. All right, I appreciate those answers. Thank you. It's cleared a lot up for me. Cheers.
Yeah, no, thanks for asking those questions, because I guarantee you, if you've got those questions, someone else had them, but they just don't want to ask them. So thanks for being the person that asks those.
Cheers, Matt.
Thank you, Sean. Simon, can we just have one last attempt, because seems like everyone else is coming on, but Lawrence Porter, if you can set him up as a co-host, that might do the trick.
Okay, well, I just added him as a speaker,
and
I'll now invite to co-host. And it's just spinning like crazy next to his name. And Lawrence, you should get a little pop-up asking you if you want to co-host.
Can you try the same with Natty?
Okay, Natty, I'm doing the same with you. So I've invited you to speak, and I'm now going to invite you to co-host. If you can accept it. Otherwise, you'll have to log in as your alt account as Celsius Loans or Cam Cruz or something. Okay, I've attempted it.
All right, let's whilst we wait for them, let's bring up Royce.
Hi everyone. Hi Simon. Hi Tony. I have a couple of questions regarding the custody and custody with the loans. Sorry if anybody asked this question before and you have answers. I'm a little lag behind the updates. So I understand that the
Hey, Tony, you're
custody.
right to listen to this one while it gets asked?
Yeah,
Just checking Tone's here. Okay, go for it.
Thanks. The custody people, the transfer custody, receiving 72.5%, regardless of preference, or are we still waiting for a preference threshold?
So the 72.5% is free and clear. So at a minimum, you'll be getting 72.5%. And then once the plan is out, if the plan says that for whatever reason there is no preference against you, then you'll get the difference. And if the plan says that there will be a preference against you, then you give up the balance. But
Okay. If in case of any
your floor is 72.5%. You won't get any less than
right,
that.
right. Okay. The follow-up question. So if we have a preference, right? So the preference amount threshold, is it only the amount that you have in a custody, or it is some amount? All the amount that you withdrew plus in a custody? Because I withdrew 20%, I would say, or maybe less than 20% before in a 90 days. So would that be also considered into the threshold?
So that's a good question. There's a lot of confusion around that. So your preference threshold, or your preference, I guess, exposure, is any amount that you removed from earn. The amount that you removed out of earn and left in custody, you're eligible to get 27.5% of it with the settlement. But whatever you withdrew, that's a whole nother ballpark. That's a whole nother ball game. The actual total exposure you have is any amount, regardless of where it is now, that was removed out of earn. So if you took out, let's say, 150,000, and the threshold is 100, then you would be subject to the 72.5%. You'll get 72.5% of whatever's in your custody wallet, but they can still go after you because you're above the 100,000 threshold for everything else. I don't know if they'll want to, but they can.
Okay. All right. So what happened with the remaining 27.5% is because in Telegram, some people's talking about we may get 100%. Because are we getting any additional tokens? And no, it's all lost. 27.5%.
So custody is not part of the estate. So any equity tokens you would not be eligible to receive. We've been joking that 27.5% is the withdrawal fee, but basically, that's basically what it is. It's a nice, gentle, nice, kind donation to the estate for our troubles.
Yeah, I paid more than 27% in Ethereum transaction. So yeah, I'm used to this number.
It's good.
Okay. And also a few other questions. Sorry if I'm taking so much time. So I understand we have to vote for this plan. So do you know when and how we can get receive the request for voting?
We should be getting some type of email, some type of notification when they're ready. And then it's just a matter of yes or no on the plan. There's going to be 30 days for everyone to vote. I am assuming once they send out the emails. And then after that, I would imagine shortly after, they're going to start the first distribution.
Okay. And what if the person have a loan and the person have a custody and also have a loan? Is there any different treatment for those people?
Yes and no, I guess technically. Previously, if you had a loan, you weren't eligible to withdraw anything for the pure custody. But with this settlement, if you agree to settle, they're basically waiving that as long as your loan is under the 80% liquidation rate. And by 80%, I mean loan to value. So let's say you're at 81%, you're super underwater. They'll hold, whatever the amount needed to get you from 81% under 80. And then the rest you're free and clear.
Okay, let's bring up the next speaker, Michael S.
Hey guys, can you hear me?
I can hear you, Michael.
Okay. Simon, did I hear you say it right? In today's meeting, they're saying that the total assets as of today is 1.9 billion.
No, the 1.9 billion is what they believe the net asset value will be of the NewCo. And the NewCo will have the renegotiated loans, all of the staked ETH, and the valuation of the mining operation in it. And they believe that will be valued at 1.9 billion. That's not meant to include all the coins that they will be distributing up front and everything they need to settle with all the other convenience classes and custody and everyone else. So there's illiquid distribution, which we estimate will be about 30%. And then there's an illiquid company assets, which will be wrapped into a company, and we'll receive equity in that company. And they value that company approximately 1.9 billion. But obviously it's a bit of a moving target, and we need a disclosure statement to understand all the assumptions behind how the investment bank came up with that valuation.
Got it. And just curious, with the crypto prices being up, as of today, your opinion was 40% we would recover?
Yeah, so to me, my big fear is that if crypto went and ripped right now, they can make us whole in US dollar terms, but the amount of crypto they pay us back goes down. And this plays into what could happen with the outcome of the equity shareholders as well in the Series B preference claim. So there is a freaky scenario, and I've always said that there's two forces here. We're better off the longer this stays into a bear market if we can get a plan out. And if we just went with the simple plan of converting everything into Bitcoin and then just distributing the Bitcoin, I think that was the simple plan. And then having equity in a mining operation, which is what we attempted to do. Obviously, there's ETH people here, so we incorporated ETH and staking into that plan. But from here, there's still a possibility that they could say, well, we owe this amount of people in dollars, like Mt. Gox, and now we're no longer insolvent because the price of Bitcoin's gone up so much. We can just pay everyone off. We could buy back a bunch. We could pay everyone off in Bitcoin based upon the value of Bitcoin to their dollar claim. Sorry, that's a very complicated way of saying it, but they owe you $1,000. How much Bitcoin does it cost you to buy $1,000? Well, the higher the price, the less Bitcoin you'll receive, but you're made whole in dollar terms. We hopefully get a plan through before anything like that happens. And there's a bit of a play in terms of creditors versus equity shareholders, and the largest equity shareholder is Alex Mashinsky himself as well. So there's a bit of a play to be aware of there.
Do you have a rough estimate as to what price, say, Bitcoin would be that we're close to being made whole on the dollar value?
Oh man, that's one for Keith. I think the problem is that you need to vote on all the different settlements. It's such a hard calculation to do. They should they should do it for us, but that would take an incredible amount of modeling and a lot of different scenarios. And it's you'd have to model the Bitcoin price, you'd have to model the crypto reaction, you'd have to model the difficulty rate adjustments in mining. You'd have to model everything in the mining operation. It's a pretty simple number, but very hard to arrive at. But hopefully, I don't know if we're going to get such forward-looking statements in a disclosure. That would normally be part of an S1 that would require SEC approval. So normally, when you file an S1, you go back and forth with the SEC to ensure everything's accurate, fully disclosed, and it's all fair, clear, and not misleading. I don't know if we're going to get that in the disclosure statement. That will be more like a private placement where you try and meet all the rules and disclosure requirements, but you can't give forward-looking statements because the SEC hasn't gone through them and understood your assumptions.
Correct. And so when you're saying 40% today, roughly, I know that's just a very rough estimate that if we went into liquidation, that's 40% on our, if it's dollarized, I would say it's more based on crypto prices, right?
Yeah, if you're dollarizing, I'm thinking in terms of 40% of the crypto is there. And then thinking along those lines, if you converted everything to Bitcoin and ETH and distributed, that's where I'm thinking. Last time I did the calculation, it was 47.5%. But you have to add some weighing to the crypto. The rebalancing is a pretty complex operation, actually. So yeah, I think they're going to want. Well, when I did the original calculation, if you just took people's crypto and gave it to them, I arrived at 47%. But there's flaws in that model as well. It's pretty tricky. It's a pretty tricky thing to do.
So it's probably more than 50% on the dollar value, right? If everything was liquidated today.
If you're thinking in dollars, yes, I think so. But I don't think in dollars. I think in Bitcoin.
Yeah. Okay. And I don't know if you can comment on this, but obviously you're under NDA about what's going on with the other bids, but are they serious? Does it look like a serious offer?
Well, our first job is to get a framework and a stalking horse. And the court hearing today was about ensuring that we don't get shafted if under a set of scenarios. So imagine they put forward a plan, then it moves into Chapter 7. What happens? These are the different things. Then what happens if it does a slow liquidation? And then what happens if the regulator says no? And then what happens if the plan gets accepted? And that's what the court hearing was about today. And Judge Glenn, I think, did a really good job at having our back and ensuring that those scenarios are understood. And then the creditors all came up, and Manny did a good job, I think, of explaining that it's hard for us to make a decision on whether we're willing to sign up to this 18 million of exposure if we don't really see the plan. And I think Judge Glenn appreciated that the two are connected. And then all of us came up and tried to ask some questions about the plan. And then Judge was saying this isn't the time to ask about the plan, but then he appreciated that the two are kind of aligned. So I think he's going to have our back and make sure a disclosure statement comes out before that determination is made. I don't know if anyone else got a different opinion, but I think that's where it ended.
Got it. Well, thank you so much. Appreciate your feedback as usual.
Okay, pleasure. Thank you.
All right, let's bring up Scott Lawrence Porter.
This is Lawrence Porter using my son.
Oh, is this the legendary Lawrence?
I don't know about legendary.
You're not doxing your son, are you?
He's not too thrilled about this, to say the least. He lost a Bitcoin, though, because we couldn't put anything in to save his Bitcoin from a small loan, and some Ethereum as well. But having said
this
that,
is extreme measures, Lawrence. You have been there's something seriously going on with you.
Yeah, I don't like anything that's going on, Simon. I'm glad to hear that you're in approval of the way NovaWulf is acting. I am really, really beside myself. We've spent over $140 million in fees already. We've got a $20 million examiner's report that was stealthily negotiated by Kirkland and Ellis so that it was not under oath. They knew that it wouldn't be admissible in court. $20 million. And they knew. They've done a phenomenal job keeping Alex Mashinsky out of jail and making this look like it was a business. My biggest problem that I have, Simon, is everybody, and I'm not saying that Judge Glenn isn't doing an outstanding job, but everybody is learning at the creditor's expense. And NovaWulf is doing the same learning. They're not experienced Bitcoiners. And I mean, they just check every box. It's not, there's conflicting with who owns the mining. B round, or as entered into evidence, I believe, and testimony, that it was the creditor's money that was used to build this mining operation. I mean, so your clarity on how you think this B round and this entered into evidence that the creditor's crypto was used to build this mining, I'd love to hear that. I'd love to figure. Go ahead.
Yeah. Firstly, Lawrence, I think you play a really important role as the eternal skeptic, and making sure that we're all on the right page of some of the things that sometimes sound like conspiracy theories, but half the time turn out to be true. So I think that's a really important role and that you're playing there. My hope is, or my understanding anyway, is that there is a $9 billion intercompany loan that has been pushed down to $3.5 billion. And those numbers become important in determining, what may happen, whether the upside goes to creditors or shareholders. And it's a very simplistic view. And as you know, I'm conflicted there because I'm both a shareholder and a creditor, which I've disclosed from day one. So take that for what it is. But that becomes an important number. And then there are two different types of defenses that are going to be determined in court to find out. My belief from all the research that I've done is that the benefit of the mining operation will most likely go to creditors, but it's several layers above my pay packet because it's a very legal thing. But there is there is a bunch of stuff that still needs to be figured out, and that's going to delay everything. But NovaWulf have kind of said we're plowing on with a plan, and these things will be figured out in court in due process.
I believe what you're saying is it's Lawyers Club, and they're allowing this law firm for the round B funders to have their say, to save face. And
well, I do think that the UCC, Celsius, and creditors are on a team versus those shareholders. And I think what you're saying is that you believe that Celsius might be on the side of shareholders, and the largest shareholder and the largest beneficiary is potentially Alex Mashinsky.
So, having said that, what are the chances of other bidders coming in here, Simon?
Yeah, so it is a very complex transaction. As you know, we were booted out as a bidder, and they gave their reasons today in court, and their reasons that came from Greg Besh was that they believe that the TradFi experience that the NovaWulf team had was superior to our kind of Bitcoiner experience, and also US first entity. And that may be true, and that may be right. And I'll leave everyone else to make that judgment call. But they also said that there is a credible syndicate, and we've been working hard behind the scenes to ensure there is a credible syndicate, so that once this is approved and we've got the terms correct, so that Judge Glenn can have us back and ensure that if NovaWulf ends up the plan, the winning plan bid and plan sponsor, that we don't end up paying, and that if anyone else does have a credible bid, they have to supersede that $18 million mark, and it does give us an ROI, because really the expenses to structure this complex deal and get regulatory approval certainly will go into that threshold. That was the quote that we were given by our legal counsel, so it does seem in line with what it would take. And so really, there may be a competing bid, but in order for those group of people to coordinate and have a chance of getting past regulators, then we just need the stalking bid, the framework structured, and the negotiations that happen today to so that we just understand the game of the different scenarios and under which scenario this just becomes a waste of money. And I think the judge is really negotiating those things and making sure that we're not just spending creditors' money without actually having a structure that works in our favor.
So, from what you're saying, Simon, I take it that you're swallowing, so to speak, that they're making the appreciation percentages on the crypto if it were to go up to $300,000 per
Oh no, we
Bitcoin.
want to push back on that. We definitely want to push back.
I'm glad to hear that.
Yeah. Oh no, that's what they're putting in the plan.
And then the other thing I brought up today, which I was shut down real quick, and I had a feeling I would be shut down, but I wanted to get it out there, is this crypto has gone up approximately 25-30%, and I couldn't hear what the judge said. It disconnected. But what's happening to that money? What's happening to that? Where's that
Yeah, he
going,
was
Simon?
poo-pooing, basically saying that he checked the prices and crypto's only gone up a small amount since the petition date.
That's wrong. It was 16,000 Bitcoin. It's 28. January 1st.
I thought it was
up.
19,000, if I'm not wrong. But yeah, it's a big difference.
It's a big difference.
Yeah. So what that does is it increases the size of Celsius's hole and makes them more bankrupt if you measure it in terms of the dollar value of all the crypto they owe. But on the flip side, they've pushed bankruptcy code pushes that in their favor, whereby because we have to settle at the petition date, therefore the higher the price, the easier it would be in order to buy everyone back and settle them in dollar terms, and then the upside go to another group. So that's just something to be aware of. It's pretty extreme, the set of circumstances that it would work, but we just need to be aware that model exists.
Understood. So the final thing I'm going to bring up, and I appreciate Azad and your efforts to get me on here. You're taking a leap of faith, an assumption that this NovaWulf is staying focused, staying interested, moving forward because they believe they're going to end up with the mining operation.
Yeah, even if they don't have the mining operation, from my perspective, if they don't have the mining operation, I think it would be very hard to argue that their plan is better than a liquidation. It would be very hard to argue that. So NovaWulf, I believe that when we get the disclosure statement, they're going to reveal how they want to take advantage of that operation. And obviously, the shareholders, they don't want to run a mining operation. They just want to see what they can construct. Because who would run that mining operation? But also, there's many people that would run that mining operation, and I know that in the bidding process, there's plenty of people that could do that. That's probably one of the easier parts.
Thank you very much, Simon, for all your efforts. And Azad, I appreciate your help today, especially. And stay tuned.
Okay, thank you. Azad, anyone else? I think you're on mute if you're speaking. Anyone else on stage want to ask a question? Natty, if you've got an alt account that you're willing to rug yourself on like Lawrence did, then you might be able to come up. I think Azad's working on something else, maybe. How are we doing for time?
Simon, you want to make me a co-host? Maybe I can figure it out.
Okay. I've made you co-host, Tone. Okay, cool. Your co-host Tone. All right. If anyone's speaking, I can't hear them. Maybe it's my issue.
Hello, can you hear me?
Here's us.
Okay, yeah, no, Twitter is definitely playing up. We've got quite a few people having issues. I've not been able to hear certain speakers speak either. So
You might need to come down and come back up if you can't hear the other speakers.
Let's try Crypto KPR.
Hey guys, how's it going?
Hey, Crypto.
Hey, all right, I got a couple questions. So, let me start with this one. It looks like we have simpler solutions, but I want to get clarity on this particular piece, and I just want to make sure that I'm understanding it correctly. So, okay, so let's look at Series B for a moment. Now they basically have an interest in the mining operation and the CNL entity, correct? And the judge has kind of sided with them. However, based on what he has said in that thread of document, I guess he's kind of putting. It's almost like they're in check because it looks like all the entities are now open for everybody to be able to submit claims against. Am I understanding that correctly?
Yeah, I'll give it a go as well because it's slightly beyond my comprehension. I've looked at it deeply, but I haven't got legal counsel
Right.
to fact check things. Grace. But yeah, basically under the existing ruling, all creditors would have a claim against all affiliated entities. And on Tuesday, the final part was who are the affiliated entities, and it might actually be all the shareholders and various other things. So it created like this double-edged sword. But he determined that by the carelessness and recklessness of the terms and conditions, that was the correct determination. And there was a reason why we couldn't go to what the essence of the terms and conditions were meant to achieve. And so at the moment, yes, so the current state of play is that creditors have claims over the entity that they entered into the terms and conditions, which is Celsius LLC. Celsius LLC is a subsidiary that doesn't sit underneath with mining underneath it or GK8 underneath it or KeyFi underneath it. It sits under Celsius Limited, and Celsius Limited is the UK parent, and the shareholders of the UK parent, Celsius Limited, are a bunch of shareholders, but 64% of it is owned by Celsius Inc. And Celsius Inc. is 86% owned by Alex Majinski and 16% owned by Daniel Leone, from my research. And so 64% of the company, and then the rest of it is investors. And it seems like the investors were misrepresented this investment because they believed that they were investing in a mining operation, and they never entered into the terms and conditions or terms of service with LLC. So they're not subject to it, which means that us as creditors, we would have a claim against all those people under the current determination. And so I hope that makes sense.
It does, and it's so tricky because of the splits and the percentages of the ownership between Mashinsky and Daniel Leone, and then how it kind of flows down into the hierarchy of the structures of these entities, right? So, and I've been looking at this for the longest time. Obviously, you know, I've been on this.
Yeah, I think you and Harry were first to
Correct.
really go into
Yes.
this, weren't you? And everyone was like, nah, it doesn't mean nothing.
Right. And now we're at this moment where, like, you know, it does mean something, and it could possibly be a solution. But is there any potential? Now, look, let's say if Judge says that he's favoring, you know, Series B for this stuff, right? I mean, isn't it as simple as, let's say, okay, you know, can we not cut a deal? Let's say if they are to hypothetically speaking, if they were to get this, let's just assume. Is there a way for us to, maybe strike a deal with them? Because if it's not worth anything to them if they are liable to, or subject to further, lawsuits, correct? Like it's almost like,
That's my understanding, and also it only really comes into play if they're above 3.5 billion in the money because of the intercompany loan.
correct. Okay, so then isn't it? Can we not strike a deal with Series B and just basically, I mean, I don't know how many Series B folks there are, but there's a lot of folks with deep pockets. If since I don't, if they're long crypto, which I'm assuming they are, why can't we strike a deal with them and just say, hey, let's use some of the proceeds from these illiquid assets from Series, I mean, I'm sorry, from the what do you call it? The CNL company, whatever the $3.5 billion that's left over after they've written off the 6 billion that used to be in there. Um, if they were to sell some of those illiquid assets to at least get a mining operation going, because what's NovaWulf estimating the cost for that at? They're saying, they're going to bring in about 50 million or 45 million, and then they need another 200 to get that stuff going. Okay, well, let's sell enough of that to get it going, and then, have a future plan as to how we're going to, um, allow everybody to liquidate and get something out of it. Is that even like within the realm of possibility?
Yeah, so of course, settlement is always the preferred option. So the UCC, Celsius, and the Series B may be negotiating a settlement as we speak, and it's probably why, it's probably why they don't want to do a space right now. I don't think they can reveal their cards
I hope so.
of
I
what's
really
actually
hope so.
happening.
That's the case. Yes.
Yeah. And so but there's also the game theory of at what point does the estate come in the money by the 3.5 billion. And so the game could be that you hold out for as long as possible for a recovery of the crypto market, and then all of the dynamics work in that favor, and then everyone can just pay off the estate in dollar terms but with less crypto, which is a nightmare scenario. And they kind of know that if you can keep objecting, and so at some point the judge is just going to have to rule. So this probably just goes to litigation. I think it's completely outside of the parameters of anything, and I think it just comes down to the judge's interpretation of the law and making a ruling, and knowing that the game could be just wait as long as possible. I think that's the game theory. I still haven't fully figured it all out yet.
And that's the weird part, right? I mean, because initially we were extended through April 17th, which, I mean, that's tax date, right? Now I don't know about the rest of the country, and Simon, this doesn't impact you at least, but I know in California we've already got an extension all the way out to October 16th. For everybody, just because of all the natural disasters that's been going on in our state. So I don't know if the rest of the country has also been extended to that, and businesses as well have been received an automatic extension for another 6 months. Um, well, so the way I'm looking at it is that, okay, if we owe taxes on something that we have not even really, let's say I'm 100% earned, and I have I owe taxes on whatever I've earned, and but whatever I've earned is basically a loss, right? So I feel like that it's kind of unnecessary and almost redundant, because now I'm going to have to recoup it later and do even more work. Now it helps the IRS, but I mean, it just complicates the process even more. So I'm thinking about it from this perspective that, all right, let's say if we have everybody's earned. If they've already, I know that, they've already made some adjustments, but because they've retracted the 3 weeks of earned that they've paid off since June 12th, when they went into the freeze, correct? And now everybody has to go back. Whoever's done their taxes has to go back and redo them again, which is freaking annoying. And I feel really bad for them because they can't do anything about that now. But let's just say if they've already done that and they've secured that in their benefit and they've reduced the amount of earned payouts by whatever X amount, why don't we all just agree to just foregoing all our earn? I mean, if the system says that they've paid out $1.2 billion in earn to date, I mean, how much earn is trapped in the platform right now that we can just, crawl back on and just forego to basically lower the size of the hole?
Yeah, I think again, I think we're just all going to have to talk because everyone's ideas are valid as we go through this process. But I think that is a Ponzi determination. I think that's one of the per se creditors is going for a Ponzi
I
determination.
see.
And by bringing that forward, Judge Glenn is going to have to rule on that. Because if you remember, Judge Glenn said to the examiner, here's the scope of what to cover. And then the examiner said, well, we're not on purpose going to determine whether it's a Ponzi or not. We're going to give you the evidence, and then hopefully everyone can come to their agreements, and custody can settle, loans can settle, Series B can settle, everyone can settle, and then we don't need to make the Ponzi determination. But now it's got to this point. We had someone's a per se creditor has hired decent counsel, and that counsel was in the court today for the first time because they're going for a Ponzi determination, which would then be doing probably what you're saying, just unwinding all of the yield, netting everybody off, and just going through this big process of clawbacks and determining what everyone's owed.
Yeah, and I know that's tricky because, I mean, we really need to understand the implications of the Ponzi. I mean, obviously, at this point, we all kind of have
But
an
also
idea.
remember, if it's Ponzi or not is not really our
You're
decision.
right,
It's
exactly.
been brought forward.
Yeah,
If it is a Ponzi, it's a Ponzi. If it's not a Ponzi, it's not a Ponzi.
true.
And no amount of us wanting something, I don't think that sways it really. I think the time for that is everyone's got to settle, and before it reaches that stage, and hopefully a plan gets approved. Otherwise, that's what I think we default back to. And that's what, yeah,
So
that's what I think it
yeah,
goes.
so I have the last thing, and I'll shut up after that. But one last thing is, this is just something I've noticed. So it looks like the convenience class is being paid out in kind, and I got this out of an Aaron Bennett video. So basically, um,
Oh, is that confirmed?
well,
So
you made an
here's the important
indication, so
part.
I cited the source just because I don't know for a fact on this, right? Like, I mean, that's just his opinion. I'm kind of reading this as well because it looks like the payout for that particular case, it does look like, is going to be done in kind. So now I don't know if that means.
Yeah, which lines up with the custody settlement as well, because custody, they're not saying in kind, i.e., we dollarize the value and then we pay you out in crypto based upon the dollar
Hmm.
value. They're saying if you had a Bitcoin, we're giving you 0.725 Bitcoin.
Correct.
If they do that for the convenience class, yeah, then there's a fixed sum of crypto that's going to be needed to bribe them to cram down the plan for us.
So, my bad. And I think I meant to say, did I say convenience class? I meant to say
Uh,
custody. My
Custody.
bad.
Yeah, custody is, Tony confirmed that earlier.
Okay, cool. I forget what I said. I meant custody. So let's say if they're paying custody back in kind, um, and so then is that supposed to be? Can we take that as a sign that, let's say, they probably will be paying everybody else, like let's say earn folks out down the road, in kind as well, or is that not?
No, I don't think so. I think custody are being paid in kind because it was ruled that their case was, this is my property, therefore give me back my property,
Yes.
and therefore one Bitcoin is in the Celsius land, one Bitcoin equals 0.725 Bitcoin if it's your property.
Yeah.
But because the rest is Celsius's property, unless that's disputed, and the judge rules, then we are going to be locked into the dollar value, and therefore I think the convenience class will get a slightly different settlement, but we'll get that in the disclosure statement hopefully in the next week or so.
Got it.
The disclosure statement.
Yes,
Hello?
who's that?
Hello?
It's Nikolai. Go ahead, Nikolai. We can hear you.
Oh, thank you. Thank you for this opportunity. Can you hear me?
We can, and I know, Azad, are you keeping an eye on who's next and stuff? But we could do you, and then we'll do Natty, because he's been absolutely... I think we've got him on the stage before he drops off. Could you mind if we do Natty first? He's been waiting a long time.
No, that's
well,
okay. Stable. I'm here now. Nicolas, go ahead.
Thank you very much. I'm one of the top 50 creditors in Celsius with my life savings in Earn. I have sent a couple of DM, Simon, to you. And I would also like to express the...
Are you in the Telegram group, by the way?
Not in the Telegram group.
Okay.
I have sent directly on your...
Do me a favor. Can you DM Azad as well? Because my DMs are crazy. I can't keep up with them.
Okay.
Yeah,
I can
the co-host
definitely
Azad.
Yes, no problem with it. I really like to recognize the energy and the contribution what you're doing. Also, I see here Plan C, Mary, Cam, CR. Really remarkable support and strength of the group. You mentioned a few times tonight that distribution in dollarized returns, they are good if happens in the bear market, but market we cannot predict. And only a reminder just to set up the base for this concept. Nearly every creditor came to Celsius for yield, not to be venture capitalist. And obviously, we like the plan, which is very similar, Simon, to the outlines you presented in the beginning, which is basically give back as much in kind crypto, accept the bid for illiquid assets and the loans from the new call, and
yeah, illegal is a good Freudian slip, probably right.
Yeah, thank you. And the number 3, insider clawbacks only. These 3 are core of basically what I can. It's my impression that most of us during these 9 months, we find to be the best outcome for us. And since you are the person who is now officially actually the legal teams.
Yeah, I'm
actually,
definitely not the legal team. Just to frame it correctly, I'm
correct.
an unpaid consultant when everyone else is being paid. I'm just muggins.
Correct.
Trying to bring some transparency to this process, and trying to be a go-between between the different parties.
Thank you, and I know that, and I'm actually you're really helping the creditors community, and of course, you're smart. I just wanted to, you're like our PR person going between the creditors community, because WNC and K&E, they're actually, they have only a couple of Twitter spaces with us. For 9 months, they're really not communicating with us. We have been, with your efforts, we came to this point, that kind of we have some strong unity. And um, first of all, I'm sure everybody's would like if you can facilitate that we get more direct Twitter spaces with White and Case, UCC. The, we are paying the legal fees, but both legal teams, which are like one of the best in the countries, they're actually for 9 months going around and around and offering solutions that actually they are not really benefiting the very sound and plan that we based on your primary offer. I mean, for the plan, they are actually they're not really engaging with us, to work on that. I would like to finish by asking you kindly, if you can use your influence, to bring them, even the NovaWulf, to intensify the contact directly with us, with the creators community. And I would appreciate, like I would like to get in touch with you even, on a probably one-to-one on a private call, since because of my position,
Got you.
with yes.
Okay. All right. Well, DM Azard. Azard will get you in the Telegram group.
Yes.
And NovaWulf have committed after the 31st of March, after this disclosure statement, to run their next space.
Correct.
I found the last space very, very useful. It started scripted. They took questions. I think it eased a lot of people's concerns, but then brought up more things. So, the more they communicate, the better. But I do think we have reached a stage where Kirkland Ellis, White and Case, and the UCC, for strategic legal reasons, probably aren't going to be able to host many more spaces because they're involved in a very big battle. And so at this stage, I'll try and bring some more transparency to the process, but I've also got to rely upon counsel to try and do what they think is right. I'm a structurer. I'm a financial Bitcoiner, and
Correct.
so I try and stick in my lane of what I do. But half the time, I end up on these regulatory and legal tangents, even though I'm not a qualified legal advisor, and the regulations was just forced upon me as part of this. So, thanks for all the feedback.
Absolutely.
I would say there's also I believe that somebody has filed one particular creditor has filed a motion to object to me doing exactly what we just said. So we have to see the outcome of that as well.
Yeah, look, can you hear me, Simon?
Yeah.
I think I'm having some technical issues myself.
Yeah.
All right, let's.
Well, I think we're right on the 2-hour mark. So I think we said we do a maximum of 2 hours. Should we just take the questions from everyone that's on the stage? And we have got Natty up.
Yeah, let's bring up Natty. Then we'll get Bugat and Orpheus, and we've got Crow 4. So we've got 4 in total.
Okay, we'll take those, then we'll wrap up. Thanks, everybody.
Okay, we'll do quick. Okay, thank you. It has been a hell to be able to speak. You hear me?
We've got Natty right now. He's got a lot of background noise, but and I think the other people can't hear. But
so I'm terribly sorry. I'm outside in the street. I've been walking a lot, not being able to follow up clearly. But I see there is no new docket today. So the main point is next Friday is 31 disclosure statement, and clearly the B series shareholder, the UCC, the debtor with Key and Milbank, the attorney representative of the B shareholder, have done a proposed order following the judge opinion that the customer only have claim against the LCC. So this is really important. Your explanation was very much more clearer today about the shareholder structure. That in the end, Mashinsky hold majority stake in the incorporation, Celsius Incorporation, which control the LTD in the UK, and the LTD in the UK is where there is all the B shareholders. And so the conspiracy theory is that Mashinsky aligned his interests with the B shareholder. So it is in his interest that there is a ruling that customer only have claim against the LCC and not against the LTD UK. David Adler was right to file a claim. Celsius misled us to not file a claim. And that's it. It looks like the ad hoc loan group has made a settlement. I hope they will get back the collateral. And that's it. And I remind that the plan we have for now is the Celsius one through the sponsor. So if anybody feels the plan is not good, this is Celsius plan, guys. This is not a competitive bid from whatever company. So that's it. So this proposed order to make the claimant, you guys have claim only against the LCC company is a report. Keep your eyes on that. And today I've seen. Thank you again, Simon, for your live tweeting. I quickly checked it right now. Mainly they was discussing about the bid protection and so on. And so it looks like the UCC is supporting it, and it will pass. That's it. Thank you. Go on with the question.
Okay, thanks a lot, Natty. And if anyone wants to follow the Chief Mashinsky DD officer, you should follow Natty, who will publish his findings as he finds them. So I think we've got our Chief Conspiracy Officer on the Twitter Bankruptcy Court.
Thank you. Okay, next speaker is CRO for life.
Hey guys, first off, I want to say thanks for bringing up, average Joes like me. I've been in crypto for a while. I've been following, the banking crisis and what's going on with the Fed, and I think this all kind of will tie into Celsius as well. But I wanted to get your perspective on something. So what I'm seeing, and maybe I'm completely wrong, but like we're having a run on banks supposedly, and the US dollar is in question of support.
Do you mind if I interrupt you? This particular one is really focused on Celsius, but I'm running a space tomorrow where I can really answer that question. If you wouldn't mind coming back tomorrow at the same time, I'll really dig deep into that. We're just in the context of really focusing on a court hearing that happened today, and most people in this space are Celsius creditors really concerned about their funds. If that's okay, I really appreciate you coming up there.
Yeah, that's fine. Thank you then. Thank you.
Thank you.
Okay, we've got a question from Phil who had some technical issues, so I did promise Phil that I'd get his question asked. So the question is on clawbacks. Does clawbacks apply only to withdrawals off the platform? There are 3 Celsius accounts in my family, and in that 90-day period, we often withdrew from one account to credit another account, chasing interest. So funds stayed on platform, but went from one account to another. One withdrawal, one deposit. Do these withdrawal transactions count for clawbacks? They shouldn't, but they do. ?
Yeah, I don't know the answer. Maybe Tony does, but I know people are in that scenario where they withdrew, which I think would be subject to a clawback. I don't know if Plan C's got the answer. And if you redeposited, then withdrew again, I think it's all subject to clawbacks, and there'll be some kind of netting effect if you still have deposits on the platform. But again, this is all to be determined in court. So there's still defenses against these things. It's but I don't actually know the answer to that. I don't know. Maybe Tony or Plan C knows the answer.
So So the netting only works is if you bring it back to your account. If you're bringing it to someone else's account, I'm not entirely sure how that would work.
True, yeah. Everyone should be treated as their own legal entity. So I had 3 accounts that I controlled or semi-controlled. I had my personal account. I had Bank to the Future had an account on Celsius, of which I'm the director, and we had another account which was some of our clients. So those are 3 separate accounts. And so, well, firstly, yeah, it's against the terms of service if you had multiple accounts controlled by one person. But if they're all different legal entities that complete a different KYC, then you may be okay there. But I really don't think going from one account to the other, they'll see you as one creditor. They'll see that as 3 different creditors if it's 3 different people or entities.
Okay, we've got our final speaker. It's Bug Out Fozzie.
Good afternoon, you intellectual studs of Celsius. I just wanted to come.
Thank you.
I just wanted to come on real quick. When you open up the Celsius app, it's suggesting a new claims bar date for GK8. I called Stretto and spoke with the manager over there. He suggested the judge, in fact, obviously has suggested those entities aren't available for claims for us. But he also said that that's up to the individual creditor whether or not they wanted to file a claim against GK8. Do you guys have any intentions of filing a claim against GK8? And if you do, how are you going to approach that and make it separate from your crypto assets that you've made a claim for already?
Yeah, this one's a bitch because the bar date and the outcome of the determination around who owns what, I feel so underqualified to answer this question. I really think it's a David Adler, and yeah, I don't think I'm going to answer this one for now because what I say just might be completely wrong. But it really does come into question. I think they're putting it there for a reason and not giving any guidance because they don't know the outcome of what's going to happen. I guess the only thing I could say is that the maximum value is they did have to put GK8 into its own Chapter 11 in, and I think it may be a Chapter 15 because it's done through US corporate in Israel, or maybe it's done in Israel. I really haven't followed that part enough, but the maximum value of it is 44 million, which is the value that Galaxy is going to be paying for it. So whether that makes 44 million as a percentage of 5.9 billion for the petition dates, it's going to be a small number just to put it in context, but I really don't feel qualified enough to answer that.
That's exactly the way I was thinking about it. I am going to file a claim against it, and exactly based on those numbers of its value being a percentage of the entire estate in comparison to my earn claim.
Great. Yeah.
Yeah, the safe.
Okay, let us know how you get on if you as you progress with that. Do you know what the dates
it's going to work out?
Do you know what the bar date is?
I think it says April 10th. Let me just pull it up real quick. I can tell you.
Okay, so we've got probably up until April the 10th to figure this out as a community, really. So if anyone wants to take on this one, then it would be great if you can give us updates as you progress.
I'll certainly do whatever I can to give any updates on my page for you guys.
Speaking of David Adler, I did reach out to David. He is currently listening in to the arguments in the Voyager appeal, but would have joined us.
Okay, yeah, David's a busy guy right now, negotiating the borrower stuff, and there's also the Voyager.
Oh yeah.
Oh, so the Voyager appeal is that the DOJ? I think. Yeah.
So
that's an interesting one.
Coincidentally, GK8 claims bar date is April 18th.
April 18th. Okay, so we got until April the 18th as a community to figure out what we think all the different game theories are. Maybe Crypto Keeper on this. I know he's taken on. It's funny how we just end up in these little segments somehow. He took on the $9 billion loan with Harry King, was questioning this right from the beginning. And I think you've just nominated yourself as Chief GK8 Restructuring Officer in Twitter Bankruptcy Court.
Yeah, I don't know if you guys want to depend on me for anything like that. I'm too much of a hothead, bro. I've already been limited to who I can call. Judges called the U.S. Marshal on me. Phoenix detectives. They don't like people speaking their mind.
Oh shit! You've had the the U.S. Marshal on you.
Oh, he called. The
Okay.
U.S. Marshal called me. He didn't even come out. He just said, "Hey, there's a bunch of people. U.S. trustee, the judge. They don't like you calling." I said, "Well, they can unlike it as much as they want, but it's my First Amendment right, and they're public servants."
Okay, we'll keep fighting for your rights.
I certainly will.
All right. Okay, I think we're going to wrap up now. So we said we'd do 2 hours. I think this was highly efficient. I think we covered a lot of ground. If you joined halfway through, do go back to the beginning. I've got a couple of tweets above here that I pinned to the top. The first is my whole thread where I was trying to listen at the same time as tweeting, at the same time as trying to figure out what was going on. So if that's useful for you, that's pinned to the top. And there was, during this space, there was a tweet from the UCC, so I pinned that to the top. And also there's a Slido, which I'll have to try and find again because it's just got buried in so much tweeting, where I tried to, you can upvote people's questions. So people are asking questions that they'd like to ask NovaWulf and Celsius and the UCC. And you can upvote others, and that may be useful just to get an indication. I've shared that with Kirkland Ellis, NovaWulf, and the UCC. I'll try and add as much transparency to this process as I feasibly can. And we'll see you after the next court hearing. Thanks to everybody that are all unpaid workers and victims of this Twitter Celsius bankruptcy court. And I think I did really enjoy the court hearing today as a finance geek, because it really felt like we're getting further along in this process and getting to the meat of what we need to cover, which is the equity structuring and the regulatory hurdles that we have to overcome, and all the settlement agreements. So it has been a pretty big week, and it was a good court hearing. And I'll update you, and I'll launch another space as soon as we get to the next stage. Thanks, everybody. Over and out. Also, if you want to go into non-Celsius stuff, I'll be doing my Friday YouTube live on the whole the Russia-China digital currency and settlement layers and stuff. I'll be covering that all tomorrow and doing a space where we can cover non-Celsius related questions and get back to the important macro trends that are happening in the real world and the reason why we all got into Bitcoin and crypto in the first place. Okay, over and out. Thank you, everybody.